Ann Taylor intends to waive Brian Koberger's speedy trial rights at a status conference tomorrow. Bill Thompson suggested the status conference be held remotely, but Taylor is insisting on being in person. According to Idaho legal framework, a waiver of speedy trial must be done in person, so this is a strong indication the waiver will come tomorrow. But okay, so what's the waiver for then?
What is the waiver for?
Yeah,
Is that the question?
so it's not happening, and
so he waived his right.
Why don't you want this happen?
Go ahead.
Yeah, but why don't you want this happening right away?
Because he doesn't have all the information.
But so they're thinking that, okay, it's still October 2nd. You have so many court hearings in between.
Mm-hmm. Well, here's the thing. The defense and
a couple more weeks.
The defense. Well, here's the thing. My take on it is that the defense. Wouldn't I wait? Oh, I can only speak from my civil experience. The defense always wants to delay things. In civil, that's how it is, because they want more information. So I don't know how it works in a criminal case, but I think because they want to be able to, I'm sure they haven't done what they need to do because there's a lot of obstacles. I don't know what those obstacles are, but like, let's say they wanted to interview Bethany Frank or take her deposition. They weren't able to. The grand jury came and smashed that. So there's certain things that they want to do.
So you don't think the alibi is that strong then? Because this is what I'm saying. Like, you have the prosecution on its is my opinion. You have the prosecution on its toes right now.
Yeah.
Scrambling all over the place. Papers flying all up in the air, and they're slipping on banana peels and shit. Like, you have them on their toes. Why do you not want to hold the pressure? I get it. Trial's coming up on, October 2nd it was. Okay, so that's a month and a week and a half away. You can't wait a couple more weeks to see if they're gonna give you the shit to keep the pressure on them? Now it's like, where's the pressure on the prosecution?
But look, they if they give you the stuff, let's say the deadlines come and they give you the stuff, you got to send that to experts to review. And so
that's true.
So there's time.
Yeah, I know that.
Yeah. So
I think what he's saying is, why not wind down the clock a little bit more?
Right. You know what? Yeah, like you got 40 seconds. It's third down and 11. You got 40 seconds on the shot clock. Wind that shit down a little bit. Before
I can't believe I just made a sports reference.
Like, that's what I'm saying. Like, kill the clock.
Well, look, I honestly, I do trials, and if I don't have all the information I need, I'm relieved that it gets moved. I mean, this is a death penalty case. I mean, you want to make sure you have everything. You don't want to go to trial and just because you want to put pressure on the prosecution.
No, that's not what I'm saying.
Yeah.
No.
You want to have everything you need.
Yeah.
So I don't.
But how do you get everything you need if you're without pressure? Because that's what she's been doing.
Yeah.
You need pressure to get what you need. And that's where I'm coming from. Not that she doesn't need time to have experts dig into stuff. You definitely do. You need all the time in the world. But when you're trying to, I'm not trying to be disgusting, but when you're trying to pop the zit to get shit out of it, you got to put some pressure on it,
No, I understand. I can only speak from my experience in civil, that the defense always wants, they always want to delay. And yes,
okay.
Yeah, they do want to delay. But I can't comment on a criminal case. I mean, I don't know what the details are exactly, but I do know that the judge hasn't made a ruling on this the genealogy stuff.
Yeah.
And
Still.
I watched Ann Burkhart's video about what she thinks about that motion. It's still pending. He hasn't given a decision.
Is that the video
So
That's
early
a
this
little
morning?
clip, I think, on
I watched
Andrew's
Yeah.
one. It was
part.
like 15 minutes or something. I
yeah,
watched
yeah,
something
yeah.
this morning at
And
work.
she changed
Okay.
her mind. She changed her mind about what she thought about the motion after thinking about it. And so she thought, well, yeah, it's going to be relevant. Yeah, they would need to have that information. And the scientific basis or the different databases and all that stuff, I didn't quite understand, but I did understand that this would be something that she would need to go to trial. If she doesn't have it,
Oh, yeah.
then you
Yeah.
need to postpone the trial.
Well,
You
I
need
thought
to
it
waive a
was
speedy trial.
okay. So this is what I was thinking, Yoli. I was thinking that because I mean, come on, they keep the last hearing we heard him say, "How could we produce something that we just simply don't have?"
Yeah.
And
They don't have
so
it.
that's
Yeah.
when I'm like, I know, and that's when I'm like, yes. Now she's letting the frickin' courts see the BS, and that's what like. So what? You're just gonna let them? And I get everything you're saying, like totally, I get it.
Yeah.
But what I
So
mean is, how is she supposed to get the information she's wanting? The information she's wanting the experts to dig into. How is she supposed to get the information? Why aren't you? You know you're not going to get the information
yeah,
because you would have got it already. Keep showing
just
the court that they're fucking up.
yeah. So in response to Caddy's question, no, my clients are not sitting in jail because I don't do criminal law when the defense delays this. So I do
What?
civil. So that's why Caddy Sunny, she posted a question. I just answered it.
Oh.
It's okay. But what I'm trying to say is that it doesn't surprise me that she would do this and Brian would waive his right to a speedy trial because they don't have everything. And when the defense says we don't have it, the question is, well, why?
Yeah.
Tell us why.
That's what she has been. That's why all the multiple discovery requests.
Yeah.
Multiple.
So when I answer discovery where I don't have what I need, it may exist, but I don't have what I need. I just say, after a reasonable and diligent search for documents responsive to this request, plaintiff cannot comply with this request because the documents requested do not exist or never existed. Or
and that's when
because
I'm like,
they're in the possession of somebody else. And so they have to tell you that they may be in the possession of somebody else. So here you have...
Is that something they have to say?
I don't know.
I'm not saying that you know for sure, but I'm saying with your opinion, would that be something that you think would be having to be mentioned, or you don't have to say? You could just say, we just don't have them. I just don't understand how you need these reports to get the profile in the first place. How do you not even have them? Shouldn't you have to answer for that?
Yeah. So
for real. No answer.
And that's where I'm handicapped. I don't know Idaho law. I'm not a criminal defense attorney. I'm not anything. But I will say this: I did get the highest grade in criminal law for my class, so I do know something. But here's the thing: I've had cases against labs where they screw up. Okay. They don't dilute the specimen. They don't do this. And actually I got an award for delayed diagnosis on a lab specimen, and I'll send that to you so you can see.
Wow.
Yeah. In California, I was the top 100 persons who got, or lawyers who got some kind of a recognition for delayed diagnosis of a child who had a high bilirubin level, and the lab screwed up with the bilirubin test. And this kid ended up with seizures. So I do know about labs. So when they say when they say they don't have this information, like the lab information. And what Ann Taylor is asking for is 6 months before and 6 months after the reliability of the testing, the reliability, meaning that certain labs have to show like the errors and
right, everything.
Yeah.
Right.
Yeah. So for the first 6 months and the first 6 months before and 6 months after, she hasn't received that. So
yeah,
so
even employees that were reprimanded for anything she wanted.
yes,
like there was a lot she was in. She should be able to have it.
Yeah.
But
So
that's what I'm saying. How come?
So this is a lab that's in Texas. I think it's in
Yes.
Texas.
Yeah,
Mm-hmm.
Ortham. Yeah.
So
Yeah.
So why don't I understand that the prosecution is relying on the lab to give them that information. But if I don't know how it works, but I would subpoena the lab records. I don't know how it works over there, but you subpoena the lab records and there's a chain of custody as to the specimens. Like you have documentation saying
There's something. Right.
So there's
like, how can we could
and when
and then the other DNA too, how come that
when the
wasn't
prosecutor when he said that he wasn't prepared for this, it's like, are you kidding me? You're in the most high profile case, and in the motion they said 3 unknown DNA specimens, and you're going to stand there and say, I wasn't prepared for this.
Right.
Oh, yes, you were. Yes, you were prepared. You're just acting. That's why I said I don't even think people care. I don't even think they care. They just want it to go away.
Yeah, they always have. That's just my opinion, though. I've always felt.
So it doesn't.
That,
it really doesn't surprise me that he. Oh, sorry.
Tear the house down and let's get everybody forget. No, you're fine.
Yeah, so I didn't surprise me that he waived the right to a speedy trial because they don't have everything they need to conclusively prove that the defense that the prosecution cannot prove to a reasonable degree of cannot prove beyond a reasonable doubt that Brian Kober committed this. They don't have all the information to prove that. And actually, the defense doesn't have to prove anything. It's prosecution. But she has to have enough information to say, look, the prosecution doesn't have that evidence.
Well, she has been. So why are they getting away with it? That's what I'm saying. She's been asking over and over and over. And finally, in court on Friday, that, it's like, when she's asking for certain documents with, how can we give you documents that don't exist? Finally, they admitted something. You know what I mean? Finally, they admitted something.
But here's the thing. There's emails, okay? And I certainly, I couldn't listen because she had a mask and there was some kind of noise, like a fan or something. I couldn't really listen totally, but there's emails talking about these documents. So when they people aren't that smart. They turn over emails, but in the emails, they talk about attachments about the documents that she's requesting. So they turn over emails that say blah, 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 and they're referencing documents that are attached. But what she got was just the emails, is what I understood. So she knows that some documents exist because they're attached to the email that she received, but they didn't produce the attachment. So where is that?
Right.
And that's
the biggest question about a lot of this stuff.
Yeah.
It's like, where is it?
Why I would never want to go if I don't know criminal law, but I do have education. And in my opinion, I would never go to a death penalty case without getting a finding on the discovery. I mean, you need to have that. And if that's not going to be provided, then you need to have a finding by the judge saying that, this was not provided because it was either destroyed, lost. And, that is the jury instruction that says that you have the ability to provide better evidence, but you're not. And so that's suspect. And there's a jury instruction on that, the ability to provide stronger evidence. So, you know, so this is all wound into the jury instructions. So you can't go to trial without having it. I mean, you have to have what you need. I mean, and I'm talking about a civil case. For a death penalty case, I would be freaked out. You can't. You have to have it.
Yeah, you have to. And it's, and that shit takes a long time to dig into. For sure.
Yeah.
So that's what I'm saying. Why don't you let the prosecution keep having egg on their face when it comes to this shit by keeping the pressure on them and continuing to ask them over and over, where's my shit?
Yeah. It's
instead
the pressure
we're over a month away.
I know the pressure of a trial in a death penalty case, I would imagine it's different. I mean, it goes both ways. I mean, you could have pressure, but at the same time, do you want to go to trial when you could have had more information to get your client off?
So is it a thing where because we're over a month out, right? Or we were October 2nd, right?
Right.
We're a month and a week and a half. So is it fair to say that the reason why this would be taking place tomorrow is because if I did wait 2 more weeks to keep putting pressure on, something could possibly happen to where we're going to trial no matter what? I can't apply that pressure for a couple more weeks to keep asking them, where's my shit? And then they're going to get, because the closer you get, the more pressure there's going to be. So I would think that you're applying more pressure to get the stuff that you've been asking for this whole time, which you still have yet to agree. Yet to get.
Mm-hmm. That thought process is one of what Ann Taylor's going through. It's what an attorney has to do in the best interest of their client. I really can't give an opinion because I don't know what's all out there. In a civil case, certainly you do want to keep pressure, but you're not in a civil case. You're not dealing with the death penalty. You're not dealing with somebody who's going to get killed. And so Caddy Sunny had mentioned a question. In your cases, do you have somebody whose life is at stake? No, I don't. So I can play those games. I can put the pressure on up until the time of trial because there's nobody's life at stake. But when you have somebody's life at stake, I don't know what game goes on. And I'm reading that DP is off the table. The death penalty is off the table. I don't know. I didn't hear that. But
no, they're saying that they think it's going to be.
Okay, so
I mean, they haven't even. She hasn't even waived it yet.
Oh, she did. I thought she did.
I said tomorrow.
Tomorrow. So there's going to be another hearing tomorrow?
Was that today? That's how I read it.
It's today, I thought.
There was something today. There's a lot of stuff that's happened, I guess, today.
Yeah,
and then in chat, I've seen people saying there's something going on tomorrow.
Yeah.
That the what do you call it? That a lot of the other dates have been vacated, and they're pushing the trial date. I guess to be determined. So there's a lot of extra stuff that's going on, like newer moving pieces.
Yeah.
Because of what happened today.
Yeah, So the things that are going through the minds of the attorneys, I can't because you have somebody's life on the line. But what you're saying, CJ, makes sense in terms of what I do. Yeah, you want to keep the pressure on. It settles cases, But when you settle a case, you're not plea bargaining for somebody's life. I mean, it's settling a case for a certain amount of money. So when you have somebody's life on the line, I'm sure it's different.
Yeah.
That's way different.
Yeah.
And I had a judge tell me, you're lucky that you're only dealing with money, because I've had to deal with cases where somebody's life is on the line and, the pressure that involves. And in addition to the media pressure, when you have people watching over you, and I've had that, and I know what it feels like. So I couldn't imagine what pressure these people are under, both prosecution and defense. And so that's why the judge says both of you are going to be bad lawyers if you don't allow this to go through. I mean, the witnesses. And, the prosecution had every right to cross-examine them. Every right. And you know what? If I were the prosecution, I would have. But why didn't they? Because they weren't prepared? Well, that's pretty bad.
I mean, it's obvious. You can tell by just...
That's
like,
why...
It was horrible. It was, like I said, if I was a family member when I was watching that on Friday and that shit was happening in front of my eyes, that's why I got so damn mad when we were watching it. Because I'm just like, man, you're just watching the shit crumble in front of your fucking face. Like, not saying that they don't have whatever, but I'm saying their preparation, their display. That's what I'm looking at. And I'm like, at least if you ain't got your shit together, you better fucking pretend.
And, even if they weren't prepared for those witnesses, based on, a reasonable, okay, this is my opinion, only my opinion, because I've had witnesses come up that I fucking didn't know what they were going to say. It's a surprise, whatever. But when you're on, you're on. It's kind of like your shows. When you're on, you get people that come on panel. What the hell are you going to do? You have to think on your feet, right? You just have to think on your feet. It's kind of like, I don't know how to explain it, but you gotta work it. You gotta hustle. You gotta figure it out. And so even if they were ambushed by these witnesses, let's say they didn't have notice, they do have notice when the witness is testifying. They can take notes. They can process the information as it's going. They could cross-examine them if they want. It's happened, and lawyers do it all the time. And you can actually think about it. Like when they're talking about when they're testifying, you can actually like poke holes, whether it's in their qualifications, whether it's in the substance of what they're saying, whether it's the assumptions that they're making when they're testifying. Are you assuming that such and such happened when you say that, when you opine to this? Like, are you like, there's so many things you can do on the fly that they didn't do. And that's why it makes me think, what the hell? Do you guys not care? Does the prosecution not care whether he's found guilty or not? Or they don't care? Like, if he's found not guilty, okay, bye-bye, it'll go away.
Well, it's like you said. It's like you said or mentioned. It could definitely be a possibility that the reason they don't have a lot of the shit that they can't offer supply is because they're not allowed to, because of a higher investigation.
Well, here's the thing. So my understanding is that the Idaho State Police was involved, local law enforcement, and the FBI was involved in this investigation. Am I correct? I mean, I don't want to...
As far as I know, yeah. Now, the FBI's part, how much? Not sure.
Okay.
To me, I don't know. To me, it seems like they just saw it and just kind of threw something out there and was like, "Yeesh."
And yeah. So am I correct that they were involved, and the reason why they were involved is because Moscow, Idaho is a small town, and they don't have all of the resources available. So they had to pull in
typically. Yeah, typically when you're in that position, you reach out because you reach out to those services, and they're there at your request. Now, when because there's two different, they can help in two different ways. One way is if they're requested. If they're requested, they can only help with what's being requested of them. So basically, MPD or ISP could have been like, hey, we just want help on this part, which is what I think took place. I think they only wanted help with certain parts. Now, once they take over the case, that's when it's completely different. That's when they can do whatever the fuck they want. That's theirs. But if they're requested first, then it's up to who's requesting.
Okay. So in other words, the Idaho State Police and the FBI stepped in the shoes of local law enforcement to assist. Is that right?
That's my opinion. My opinion is that because I've seen it with so many other cases where there's some shoddy shit going down, I mean, hell, Henrietta, Oklahoma is one of them. Those local LE reached out because they reached out for a reason, so they could only have them to a limited part. And then when it got to be so bad, the state took over.
Yeah.
The OSBI took over
Okay.
because it,
So
and then they were like 7 days late because local already freaking did what they did and contamination was all over the place. It's what they wanted to have happen. We'll request them so they can only be available for certain things that we request them for and nothing else. And they did it on purpose. And that's why I think it went down like that. That's just my opinion though.
yeah, well, okay. So
It just
if
makes
the
sense.
yeah, and it is an opinion because I don't know how. I mean, I've been involved in public entities, but I don't know how it, like a small town, when they request assistance, what happens. But if so, if they requested assistance from Idaho State Police and the FBI because they didn't have the resources, then Idaho State Police and the FBI step into the shoes of local law enforcement. They have to do the same kind of investigation that local law enforcement would do. There are no special requirements for the FBI. I mean, if
Right,
the
there's
FBI
not.
is going, yeah, if the FBI is going to do something, they need to document. They need to document the chain of custody. They need to give. They need to be able to articulate why it is that Brian Koberger is a suspect. I'm not sure that I have that answer. And
Because
when
I
I
don't think it
ask,
was acquired
yeah, and so
the right way.
so how did like I would love to ask the anybody or anybody involved in this investigation, how did you determine that Brian Koberger was a suspect?
I've
How?
got a theory on that.
That's the
Tell
biggest
us.
question. Yeah, that's the biggest question. Like, how?
Tell
Why
us,
is his?
Dolphin.
Why?
Tell
What
us.
the sheath?
Yeah. So this past weekend, I was up, really late at night, talking to some different people in
When aren't
Discord,
you?
as I do, right? They asked me a question about the IgG results, and did I think that if those got discarded, if they still had enough of everything else, to convict him or whatever. I start thinking about the IgG and thinking about exactly what you were saying, Yoli, as to how did they get him? You know? And I started thinking about it and talking it out. And then I was like, okay, we know at the very beginning, the basic info was they found DNA on this sheath, trace DNA on this sheath. They sent it to the Idaho State Police lab, which is actually a lab at WSU on their campus. Okay. They tested the DNA. They found out that it belonged to a male. That was about all they could find out at the time. Then they ran it through CODIS. They didn't get a result back, which means that it's a male that has never been convicted of a crime. Okay.
Right.
Then they decided to send it down to this, special lab, that does IgG testing in Texas. I forget exactly where.
Awesome.
And all this time, we've been thinking that, okay, from that point, they got some sort of a match to someone in his family, some relative. And then they did this reverse engineering to, build a family tree and back into, like his family, like closer to him. Okay. And that also we've been led to believe that they had the white Elantra. There's the policeman from WSU who decided to,
Hmm.
query the database there, see how many white Elantras they had, and provide that to the Moscow Police Department. Okay, so we've been led to believe that they already kind of were onto him because of that, and they were following him or whatever when he went across the country to go home for Christmas. Okay,
Mm,
they went to
maybe.
the neighbor's garbage and grabbed the trash that they saw him throw out. And then that's how they got his father's DNA. They tested, everything in the trash or whatever, and they matched his father. And then they came out with these results that, were like, oh, the person, that this DNA belonged to was 99.99% the father of the person whose DNA is on the sheath, and which we know is a male. And as we know, what's his name? Papa Koberger only has one known son, two older
Mhm.
daughters, right? So then they, put everything together for the arrest warrant and all that. And then they said in that, hey, we have this IgG information, but don't necessarily rely on it because we have all of this other stuff, right? So they got the arrest warrant, they arrest him, on December 30th, and then they do the cheek swab, and then they're like, aha, now this definitely matches, the DNA that was on the sheath. So I was thinking about it while I was talking it out, and then I remembered that there was a news reporter who interviewed one of Brian's old neighbors at the apartment complex that he lived at, right? And that guy said, oh, yeah, we were having a conversation, and Brian said something about he wanted to do some DNA testing because he wanted to learn more about his family heritage or something like that, right? And I always thought that that was weird that he was having this conversation with this guy when, everything that happened, right? So, and then I was like, when they had the hearing last week, I was looking at them when Anne was, making her argument about the fact that hey, we think that the state has stuff that, that we think that there's stuff the state hasn't given us, right? Like we know there's information from the IgG that the state hasn't given us. And I was looking at the
Mhm.
table and I thought, okay, she's really confident. So, and at first I was thinking it's because of his background. Maybe he's familiar with IgG testing and maybe he realizes, hey, this should be here, this type of report or whatever, whatever. And he's been telling Ann Taylor, this is what's missing. And then I kept thinking, and I was like, oh, snap. I don't believe I didn't think about this before. Is that the reason I said I was thinking, you know what? And I hadn't heard about this Vargas woman. I haven't even seen all the testimony or the court
Yeah.
video footage from the
Wait, is it
hearings.
was there part of it that wasn't shown or something? Because that's what I've been
I
hearing.
don't know. I think there were just the videos were just clipped and, all over the place. And then I was doing different things. So I
Okay.
never watched it. But um, I basically said, wait a minute, what if when they were doing the IgG testing, what if they actually matched directly to Brian? Through like a 23andMe or whatever, whatever. And then I remembered I was looking for some videos to kind of like help out, to show you guys like some differences, with DNA and all that. And I remembered I found one video that said, oh, these companies over here, they don't share their information with Ellie. These companies over here, they do. You can opt into it or whatever and all that. And I said, wait, if he did the genetic testing, like he did a 23andMe or whatever, so he's actually in the system. If they did the IgG testing and it's a database that they weren't supposed to go into,
Mhm.
one that doesn't share with LE,
Right?
that would totally
Right?
explain why they don't want to turn over
And
any paperwork that has
that's
to
what
do
I
with
think took
IgG.
place. That's what I think took place.
Yes.
hmm And they have just
That's what
been
I've thought.
trying to lead us to think that it was a relative and whatnot. And see, he knows that that's how they got it. And that's why
Okay.
he was so
That's why they're
confident
pushing
about
so
being
hard.
exonerated.
Right, that's
hmm
why they're
Yeah.
pushing so hard because they
So,
hmm
know
yeah.
you ain't got it and they want to keep and that's where I'm coming from with the pressure. Totally
Yeah.
understand, but that's where I'm coming from when it comes to the pressure cuz to me it's like there's a lot of other stuff too that you could be putting pressure on to make it like come on, show us your cards. Well, we don't have them,
Yeah.
I guess. That's what but maybe it is a thing where, you toe too close to that damn line and you might fall into it. So I
Yeah.
hmm
totally get that too. Totally
And
understand.
so I like I said, I haven't been in that situation, so I can't even
Yeah.
delve into that, but I would be more cautious than, you play a game, right? You could put pressure, and if it's about money, no
Hmm.
harm, no foul. But if it's about somebody's life, I don't know. I might be
Right.
a little bit more I don't know, and so I can't really speak to that other than I would want every single thing that could exonerate this guy. And if that means pushing the trial and waiving your speedy right to a trial, then that's what it is. But so so what Dolphin said, I agree with it. Like, I have a hard time wrapping my head around it because it involves DNA and all this shit. And I have my own cases that I have to deal with. I only have so many brain cells. So I see what she's saying, but here's the thing. Go ahead.
Do you see her hiring somebody else to help her? Because I know she's all about the technicality stuff. But with all this other stuff that she don't even know about, do you think that she's going to hire somebody to her team? Or could she hire somebody to her team that is... I don't know how the public defender shit works.
Yeah. So
do you think that there could be like some kind of addition to the team where they know all of this shit and they know what to ask? Like, like they can hammer that shit. You got your DNA experts that you can put on your team. You got all these other, that's what their background is, Is there somebody? Do you see her?
Well, that's the whole point, is that this is an emerging area, right? So
yeah,
it's
exactly
confusing.
So I will give you an example. I handled these cases on people who donate their bodies to science, and it's a question about certain things that haven't been challenged, in the court of law, like the Uniform Anatomical Gift Act. When you give your body to science, they can't sell body parts, So, right. But it was kind of an iffy area. So in this case, there's an iffy area with regards to this emerging genealogy thing. And so when you have this and you don't have experience with it because it hasn't come across your desk, meaning this attorney Mercer from Maryland may have had experience with this and has more experience than you do. Well, you need to show what it is that you need in terms of experts. So you can't, like for me, I can't determine what expert I need unless I review the medical records.
Mm-hmm. Right.
Like if I get a call from a client, the first thing I ask is, get your medical records. Because I don't know.
Well, yeah, but if you're talking about DNA, then it's about DNA.
Yeah, but there's various... there's various experts that specialize in various things. And
I'm sure.
And I've done cases of birth injuries where the defense tries to say it's a genetic, something that's genetic. And we have to refute that. There's certain experts in certain fields that you need to know about. I mean, a geneticist, you can't just hire any geneticist. Like, you need to know who the hell you're going to fucking hire. Like, do you want to hire, like, I had to hire somebody from Massachusetts who was a specialist in this certain rare genetic disease to say, this is not genetic. This is a birth injury. This is because they didn't take the baby out in time. You know what I mean? So to me, what Ann Taylor is trying to do is to say, look, this attorney has had experience with all of this stuff. You need to know, you need to have the paperwork in order to determine who you're going to hire. So yes, I think that there is a possibility that there may be experts hired. And that's a whole other reason to delay the trial, because you need to know whether that information exists, whether you're going to get it. And whether you're going to,
it's just over a month away. I'm like, to me, I'm just like pressure.
Yeah. Well, it's understandable. In my particular case, I would say pressure, but I'm dealing with money. I'm dealing with death. You can't bring the dead person back. So, I'm dealing with money. Yeah. I'm not dealing with somebody's life.
Mm-hmm.
So it's just one of those things where, sometimes I wish I would have gone into criminal law, but the one thing that judge had told me is it's a good thing, just imagine if you're dealing with somebody's life, and we're just talking about money here. in my field. I can't, and that's why when I said what I said, I was hearing everything. I said, God, dumbasses, and I spoke out of turn because I was angry, but I don't know what they're dealing with. I don't know what the prosecutor's dealing with. I don't know what Ann Taylor's dealing with. And the pressure of the media, for goodness sake, I know it. I know that pressure. And so why would I say dumbasses? It's because I was pissed off. And so it's a godsend that I didn't have the ability to say more because I was with my friend. So, and so my understanding is that the decision on this genealogy DNA, whether or not it's a discovery motion that is supposed to be decided upon at some point, it hasn't been decided upon. He took it under submission.
Yeah, we'll see. I mean, I don't know. I'm surprised. I don't know. It's you got all these dates a couple days ago, or last night,
Mm-hmm.
and or yesterday, and then okay, StreamYard, you got all these dates yesterday, and then now, it's a good thing I didn't put in PTO because now they're all going to be changing again. Oh, I wasn't ready for my damn video. Oh. All right, make sure I'm ready. All right, we're good. Come on, StreamYard.
Okay, let's get on the record, please. Thank you. We are now on the record. This is State of Idaho versus Brian C. Koberger, case number CR 29-222805. Mr. Koberger is in the courtroom. Ms. Taylor is representing him. Looks like Mr. Lobston is participating on Zoom, as is Ms. Bassett. And we have Mr. Thompson and Ms. Jennings in the courtroom representing the state. Participating on Zoom is Ms. Beatty and Mr. Nye. Also representing the state, I've got Ms. Engler is the court reporter. She's participating on Zoom. And I think that's really everybody that I have to address here. So the defense, Ms. Taylor, requests a status conference for today. So here we are. Go ahead.
Thank you, Your Honor. Your Honor, we asked for this status conference today because I have had some opportunities to meet with Mr. Koberger and talk about his trial date and his speedy trial plan. Your Honor, we're here today to ask the court to continue.
We get to listen to the microphone that's sitting next to the freaking lady. What is that called? The lady that types in all the
Court reporter.
Stenographer.
Yeah.
My lord, it's better than what the other one is, though. Yeah, it's the stenographer.
Continue the trial setting, and Mr. Koberger is prepared to waive his right to a speedy trial. Your Honor, there are a couple of things that I need to place on the record. One can come after the court takes his waiver, but one I think ought to come.
Yeah, this is live. Well, it's on a delay.
As the court knows, we will file a number of motions to strike the death penalty in Idaho.
Oh, actually, it just got done 2 minutes ago, so it was on a delay, but now it's done.
After the court takes his waiver, but one I think ought to come before the court takes his waiver. Your Honor, as the court knows, we will file a number of motions to strike the death penalty in Idaho's senior capital punishment. Because we're here today to waive speedy and ask the court to continue know that one of the motions that we will be filing is a motion to strike the death penalty because it places Mr. Koberger in a position where he has to choose between two rights. One, that being the right of the speedy trial, or the other
So she said that they're going to try and strike the death penalty because it only allows him two paths to choose what path he's going to go down or something. Let me rewind that a second. They're going to strike the death penalty?
I think the court and counsel are. Your Honor, as the court knows, we will file a number of motions to strike the death penalty and Idaho's scheme of capital punishment.
On StreamYard.
Because we're here today.
Gosh, I was trying to pause it like 5 seconds ago, StreamYard.
Your Honor, as the court knows, we will file a number of motions to strike the death penalty.
The court knows that they are going to file a number of motions to strike the death penalty.
Do they have closed captions on this?
No, they don't.
Oh, okay.
I've already tried. It says unavailable right now. I don't know if it's because it just came out. Maybe after a bit it will. And if anybody has a court TV version that doesn't have shit audio, please let me know if you can send it to me, because I really don't like playing Law and Crime, but I have to if I have to, you know. I'm gonna rewind that just a tad, and then she's gonna. Can you guys hear her? Okay.
Well, I can. I mean, it's garbled. I feel like it's a Charlie Brown teacher's talking, but I can sort of make out what's happening. But
okay, because I can hear it fine. I mean, it is difficult, but I can hear what she's saying. I can kind of just let her say a couple sentences, and if you guys like, I can always pause it and repeat it to you guys if you'd like.
It's okay. Yeah, go ahead.
I'm sure after a little bit they'll have the closed captioning up for everybody. And here, I'll share the link to this video in chat if you want to save it to your playlist, and I will send it in private chat too if you guys want to keep it. There's that.
Thank you.
All right.
This conference for today, so here we are. Go ahead.
Thank you, Your Honor. Your Honor, we asked for this status conference today because I have had some opportunity to meet with Mr. Koberger and talk about his trial date and his speedy trial right. Your Honor, we're here today to ask the court to continue the trial setting, and Mr. Koberger is prepared to waive his right to a speedy trial. Your Honor, there are a couple of things that I need to place on the record. One can come after the court takes his waiver, but one I think ought to come before the court takes his waiver. Your Honor, as the court knows, we will file a number of motions to strike the death penalty.
Same thing. They're going to file a number of motions to strike the death penalty. Yeah, this is from like 10 or 15 minutes ago that it was posted. It happened at 2:15 p.m. Pacific.
Because we're here today to waive speedy and ask the court to continue, I think the court and counsel ought to know that one of the motions that we will be filing is a motion to strike the death penalty because it places Mr. Koberger in a position where he has to choose between two rights. One, that.
So it puts him, they're trying to strike it because it places Koberger in a position where he have to choose between two roads.
Position where he has to choose between two rights. One, that being the right of the speedy trial, or the other right to effective assistance of counsel.
So either waiving the right to a speedy trial or waiving the right to effective assistance.
Okay. That makes sense to me anyway.
So those are the two roads. The road of which one do you want less of, I guess, is what they're saying. And that's why they're striking the DP. Makes sense.
Yes.
Because they don't have the information that they have in order to fight. You know what I mean?
Correct.
Like, yeah,
Correct.
It goes back to the information that they're not giving them.
Yes, and in a civil case, like a civil case, we're talking about money. Yeah, you could put the pressure, but when you're talking about somebody's life, I don't know. I think you need to have the information.
Well, yeah. I mean, it's only fair. It's only
I think
fair.
So, yeah.
You know, because really it's supposed to be the burden of the prosecution.
Correct.
To, show that the defendant is guilty. It's not his job to show that he's innocent. And the thing is the shit that they should have to show, where's it at? And that's why I'm like, when I heard that the judge was being hard on Ann Taylor yesterday, I'm like, why is he not being hard on the frickin' prosecution for constantly not being able to give the shit that the fucking defense needs in order to fight their case? They have 4 cards out of 5, and you're playing with 5, and you just keep saying, no, we have that other card for you. Okay, no, we don't. That's not fair.
No, they're saying, we've already, well, it's misleading because they say we have already provided all the information we have to the defense. Okay, so there's certain information that you should have that you don't have. Is that because Idaho State Police did it? Is that because FBI did it? Well, guess what? The Idaho State Police and the FBI, they stepped in the shoes of local law enforcement to assist. At least that's what my understanding is. So you step into the shoes of local law enforcement, you need to do what local law enforcement would do, and that is to keep notes, that is to record, interviews, that is to make sure you have adequate records as to the chain of custody. Yeah, just because you're Idaho State Police and just because you're FBI doesn't mean that you can disregard that. And, I feel for the prosecution, and I don't want to say that I just think that he's working with what he has. But, you can't be disingenuous. You can't, if the FBI didn't keep records, you need to say that. You need to say, the responding party cannot comply with this request because the investigating personnel, i.e. FBI, did not keep records. And that's why we don't have it. And I think that's what Ann Taylor wants. She doesn't want them to say, we've already provided everything that we have to the defense. And there's a difference. There's a difference in that. I mean, I could say I've already provided everything I have to the defense. Okay, there's certain things that need to be in place. So why don't you have them? I don't have them. I've already provided everything that I have. No, you have to say, I don't have them because the people who did it don't have it. And that's fatal.
It's gaslighting. Fatal. It's gaslighting.
And it's fatal to the case. I mean, like I said, you have blood samples, you have samples, and I know this because I've had a case where there's labs involved and the chain of custody, it went from here to here to here. And same thing with those 3 unidentified DNA samples. You got to say it went here, from here to here. And there's people signing off. I received this, this, and this. And I actually had a case where there's pathology slides about the woman's uterus that had an infection. The defense was saying that my client had an infection. That's what caused the birth injury, but they couldn't substantiate the chain of custody with regard to the slides. So they couldn't substantiate how the slides got to the defense expert.
Yeah, because even if anything, there's paperwork on the chain of custody.
Yes. So
you know what I mean?
So we settled that case because they couldn't provide that. And so, you ask for this information and you say, okay, the lab took samples of the placenta. Okay, those samples were secured in a cassette in the lab. So what happened? How did you get it to this expert? And they couldn't provide that. Okay, so what did you send to the expert? Well, we sent them the slides. Well, how did you do that? Well, we just sent them the slides. Okay, no, you have to have somebody saying that they took a sample of the cassette of the placental cells, stained it on a microscopic slide, and therefore took it and sent it to the expert or to the defense counsel. And so then the defense counsel would have to say, yes, I received this. So there's multiple layers. You have to have all of those layers that say this is how it went down. And if you don't have that, well, it's fatal. As in a civil case, I mean, in a criminal case, I would think it's more important. But that's just my opinion. That's just my opinion.
It's way more important, especially with what the dude's facing. Yeah, if you don't have a chain of custody, you don't have evidence. I mean,
well,
that's the minimal shit right there. The chain of custody is the very beginning of everything. You know, what's being
just like
done,
bodies,
where it's going,
you know?
who's like
you have people
you have
who
to
die.
have that.
Yeah, you have people who die in a hospital. They go pick up the body. They sign for it. They're receiving the body. Then they go to the mortuary. Well, the mortuary has to sign for the body. Okay. And then, you have the embalmer who embalms the body, and they have to sign that this is the body. So it's a chain of custody. I mean, it's like, you got to have that. If you don't have documentation close in time, you don't have
shit. Yeah.
I mean, I don't know how you prove it. And in a death penalty case, I mean, Jesus Christ, I can just imagine. I would be freaked out. And if I were the judge, well, honestly, sometimes I want to just jump in and just do what I do, but I don't know. I haven't done criminal law. I'm not licensed in Idaho. I'm a civil attorney, not criminal. But I can imagine the weight, of having somebody's life on me. And believe me, I can say this because, and I'm not criticizing any of the attorneys because I have no idea what they're going through, but, just looking at it, I would not leave that courtroom unless I was able to get a finding that you people don't have it, you destroyed it, didn't do it, and you don't have proof.
And that's where she was getting, because this last court hearing, they were finally admitting that they don't have it. And
they're
that's
saying,
why
it's not in our possession. We just don't have it. It doesn't exist. Well, right. I don't know that that's true.
How can we supply something that we don't, that doesn't exist, is what he was saying. How can we supply it if it don't exist? And he was sitting there like being serious about it. And then I'm sitting there going, dude, you got families sitting back there listening to this shit? Like, we didn't test the other ones, and you're like, wait. And is that why they hired a PI in the beginning as well? Is it because, I mean, hell, we didn't trust the frickin' Ellie from the get-go. None of us did, and we're YouTubers.
And right.
I can imagine what the family feels.
And I shouldn't be...
Yeah, I know. I got it up, Mitchie girl.
I shouldn't be criticizing these attorneys because I don't know what they're under. Civil is so different. It's completely different. And I do know the media pressure where you have to contain yourself. I do know that, but I don't know what they're under. And criminal law is so different because the burdens of proof are different. And so I could never really criticize them other than stating my opinion, which is you take it what it's worth. I'm a civil attorney. I'm not a criminal attorney. So, with that said, yeah, but there's certain things that you have to understand about criminal attorneys and civil attorneys. Civil attorneys, it's a lower burden. It's completely different.
Yeah, we're going to listen to this one. All right. So she's talking about striking the DP.
The speedy trial or the other right to effective assistance.
So 2 roads.
I didn't want that to come filed later and have it be any surprise that I knew it was coming. It will be coming. That motion will be coming. And for us to stand up and request a continuance and late speed.
Questions? Well, you heard all that, Mr. Koberger? Yes? Yes. And
I'm ready for the trial.
The case that you want to waive your speedy trial rights? Yes. Do you understand that those rights are statutory in Idaho, also protected by the United States Constitution Constitution and the Idaho Constitution.
Yes.
You understand that if you waive, you're waiving really forever in this case. So if we were to push this out, this case, and then something else happens that allows us or requires us to push it out a little farther, you can't claim your right to a speedy trial at that point. You understand that?
Yes.
So have you had enough time to discuss this with Ms. Taylor?
I have.
Has anybody pressured you to waive your speedy trial rights?
No.
Sure you want to do this?
Absolutely.
Okay. Do you agree with this, Ms. Taylor?
Your Honor, I do agree with this.
It's the stenographer that's typing. They must have their microphone like right in the middle of the courtroom or something, I'm thinking. And so that way it picks up everything. But I don't know. It was weird because when in the beginning the sheriff came up to the camera and you could hear him talking. So I don't know where exactly the microphone is. I'm just all I can tell you is that's probably I don't think a reporter's typing that much. It's got to be the stenographer or whatever. So it has to be.
Do not believe counsel can be effective.
$10 Walmart microphone.
In either phase, if we should end up in a part 2 of this trial, our investigation is not complete. Our work with experts is not complete. We haven't completed our review of the state's evidence. I do not believe that we can be effective.
Is Mr. Koberger willing today to write, to sign his name and you to sign your name on a waiver of speedy trial?
Your Honor, I can tell you that I did not prepare Mr. Koberger for that, and that would be because I am not familiar with court's practice. I expected we would wait and open the court today, and that would be sufficient. I'd be happy to take a look at the full process to represent.
Well, I wasn't really anticipating this, but just in case, and hypothetically, I grabbed a Odyssey form, which I don't really favor those forms, but I did pull that out, and maybe I could give this to you and Mr. Koberger, and you can take a look at it. My practice is always to get a written signature of waiver in any waiver of speedy trial. So, let me go to.
It might be when. Ooh, that's a cool icon photo.
I haven't taken his waiver yet. I'm going to notice that, but just want to let that settle for a second. Mr. Thompson, do you have any objections?
No, Your Honor. I mean, I think everybody would like to have this resolved sooner or later, but I think the case here is such great importance and complexity that this is a smart move.
You would think that they would, but you know what? They don't even really want the camera in there, so that's probably why they're like, who cares? Right? They're like, who cares if it's by the stenographer? We don't even want the damn camera in the courtroom anyway. Who cares? I don't know. I'm thinking, see, it's got like this tripod sitting on this desk right here. So if you're looking at Bill Thompson and then there's that desk straight ahead of him, see where that little white square that's on that desk, and there looks like a cup underneath. It looks like that camera or the microphone for that's either a web camera, but I think it's a microphone for the feed. It's the microphone's got to be around there somewhere because I believe the stenographer is right up there. No, it's got to be right because if you're hearing that, it's got to be right by them. Has to be, but they don't care. They don't care if we have clear audio or not. You know, they don't even want us in there. The speaking more yeah, that's what it seemed like. Yeah, I think the stenographer's straight up and then to the left. Like, see, there's that little table with the tripod, and I think that probably has the microphone on there because the stenographer's right off to the side of that, and it's got to be where the microphone is. The microphone and then the webcam together right there. That's facing the prosecution and the defense. That's on that TV screen.
Thank you.
Yeah, let me rewind this part. It's so hard to hear.
Let me go to, and I haven't taken his waiver yet. I'm going to notice that. But just want to let that settle for a second. Mr. Thompson, do you have any objections?
No, Your Honor. I mean, I think everybody would like to have this resolved sooner than later, but I think the case here is of such great importance and complexity that this is a smart move.
Thank you.
I couldn't tell.
I do agree with
I'm sorry, I couldn't tell what he said. I could not tell.
do you have any objections?
No, Your Honor. I mean, I think everybody would like to have this resolved sooner than later, but I think the case here is of such great importance and complexity that this is a smart move.
I have. All I got out of that was a smart move. I really couldn't hear shit what he was saying because, yeah, I just got a smart move out of it. I don't know what else he was saying. Mouthful of ish. Yeah, right? A mouthful of fucking marbles. What? Good idea.
Thank you. I do agree with that. I mean, we have so many things going on. There's a lot of issues left to resolve. And as you know, I probably could understand that. And you were all thinking this.
It's like you're giving them more time to come up with something, though. You know? That's... The sound quality is off. Yeah, there is no reason why they got microphones right in front of them. Why aren't they tapping into those audio sources, you know? It's called a connector. They make them. It is. It's awful. It is. It is awful.
It's going to be very difficult to put everything together that needs to be put together before October 2nd. This is a very significant, complicated case for all the lawyers, and particularly for Mr. Convo. So I understand you want to be fully prepared for the trial.
They're not gonna have them. What's that?
Sorry, there's a transcript with this video. I
Is
just
there?
pulled it up in another window. It's the little three dots to the right of share. It says show transcript at the very bottom.
I don't have that.
Really?
Yeah,
Are you on the
download,
Law and
thank-
Crime version? That's the last thing I clicked
Oh yeah.
from StreamYard.
Yeah.
Oh.
What version are you on?
That
Are
was
you on
the 18-minute version. Has a transcript and what is this? Is this the Court TV one?
No, this is Law and Crime.
Is that 18 minutes? 1805?
Yeah. Yeah.
Yeah, that's the
1805.
same thing. Yeah.
Yeah, it's just.
I clicked the link that you put in StreamYard.
Let me refresh. Maybe I need to refresh it.
Maybe look at what time you're at before you do. Oops, never mind.
Yeah, there it is. Show transcript.
Yep.
Uh,
No problem,
okay.
Eddie.
I guess I'll. That sucks. Then we won't be able to see it. Can I get that on the window? Can I share both? No.
Reduce
Maybe
your
if I
video size. Put your
go
video
theater
size
mode.
back to, what is it, default? Or
Yeah, there we go. There we go. Yeah. Theater mode? Nope, not theater mode.
no,
Default.
mine's
Okay,
not. Yeah,
there
there
we
you go.
go.
Now it's on the side.
There we go.
We asked for this.
I'm just gonna start it over, okay, since it's showing it. We only went in a few minutes, so.
Oh,
let me
yeah,
see.
closed captions is up too now.
Yeah, we'll
So
put that up there
whichever one.
too. Why not?
Mhm.
You guys want closed caption or transcript? Do you want closed caption or transcript? Let's see, closed caption. We'll do both. Why not? Because you don't really get a good view anyway. Closed caption. Do you want the zoomed in? You want it zoomed in then, or do you want both? I'll just keep looking. Keep typing. Let me know.
I am included on this. Okay, let's get on the record, please. Thank you. We are now on the record. This is
There we
State
go.
of Idaho.
Let me get rid of that.
Brian C. Koberger, case number CR 29222805. Mr.
Is that hard to see both of them like that? Maybe I should go closed captioning, because then I bet the words show up more. Are these larger font?
Ms. Taylor is representing him.
Is it going to show it?
Looks like Mr. Lobson is participating on Zoom.
Why is it not showing it on StreamYard?
Asset. And we have
1 second.
Mr. Thompson and Denny.
It's
There we
not
go.
showing up in.
Here we go.
Oh, it's just taking a bit.
This is my border.
Participating on Zoom is Ms. Beatty and Mr. Nye.
That's probably better, huh?
Representing the state. I've got Ms. Engler is the court reporter. She's participating on Zoom. And I think that's really everybody that I have to address here. So,
What's up, everybody hopping in?
the defense, Ms. Taylor requests a status conference for today. So here we are. Go ahead.
Thank you, Your Honor. Your Honor, we asked for this status conference today because I have had some opportunity to meet with Mr. Koberger and talk about his trial date and his speedy trial right. Your Honor, we're here today to ask the court to continue the trial setting, and Mr. Koberger is prepared to waive his right to a speedy trial. Your Honor, there are a couple of things that I need to place on the record. One can come after the court takes his waiver, but one I think ought to come before the court takes his waiver. Your Honor, as the court knows, we will file a number of motions to strike the death penalty and Idaho's scheme of capital punishment. Because we're here today to waive speedy and ask the court to continue, I think the court and counsel ought to know that one of the motions that we will be filing is a motion to strike the death penalty because it places Mr. Koberger in a position where he has to choose between two rights. One, that being the right of the speedy trial, or the other right to effective assistance of counsel. I didn't want that to come filed later and have it be any surprise that I knew it was coming, it will be coming, that motion will be coming. And for us to stand up and request a continuance and waive speedy today. The rest can be placed on the record after the court's questions.
Thank you, Ms. Taylor. Well, you heard all that. Mr. Koberger? Yes.
Yes.
And is that the case that you want to waive your speedy trial rights?
Yes.
And you understand that those rights are statutory in Idaho, also protected by the United States Constitution and the Idaho Constitution?
Yes.
You understand that if you waive, you're waiving really forever in this case. So if we were to push this out, this case, and then something else happens that allows us or requires us to push it out a little farther, you can't claim your right to a speedy trial at that point. You understand that?
Yes.
So have you had enough time to discuss this with Ms. Taylor?
I have.
Has anybody pressured you to waive your speedy trial rights?
No.
You sure you want to do this?
Absolutely.
Okay. Do you agree with this, Ms. Taylor?
Your Honor, I do agree with this. I do not believe counsel can be effective by October 2nd. The entire phase, if we should end up in a part 2 of this trial, our investigation is not complete. Our work with experts is not complete. Having completed our review of the state's evidence, I do not believe that we can be effective by October.
Thank you. Is Mr. Koberger willing today to write, to sign his name and you to sign your name on a waiver of speedy trial?
Your Honor, I can tell you that I did not prepare Mr. Koberger for that, and that would be because I am not familiar with the course practice. I expect that we would wait and open court today, and that would be sufficient. Be happy to take a look at it for 4 months.
Well, I wasn't really anticipating this, but just in case, and hypothetically, I grabbed a Odyssey form, which I don't really favor those forms, but I did pull that out, and maybe I could give this to you and Mr. Koberger, and you could take a look at it. My practice is always to get a written signature of waiver in any waiver of speedy trial. So, let me go to, and I haven't taken his waiver yet. I'm going to notice that, but just want to let that settle for a second. Mr. Thompson, do you have any objections?
No, Your Honor, I mean, I think everybody would like to have this resolved sooner than later, but I think the case is of such great importance and complexity that this is a smart move.
Thank you. I do agree with that. I mean, we have so many things going on. There's a lot of issues left to resolve. And as you know, I mean, you probably would understand that. And you were all thinking this.
All right, and I'm going to take the time to pause it just for fair use. I know I probably went past that time limit, but I kind of wanted to get us back to where we were at with the closed captioning. And Yolie, that's exactly what you were saying. They all, even the judge is saying, he thinks that's what's best for both parties is for everybody to have more time. So I get it. It just sucks because I was hoping they'd be asking to be provided with more stuff and then have to admit that, they don't have it. That's why they've been repeatedly asked over and over and over for certain things. No, I don't. I don't think that's who it is. Yeah, that's what it is. Especially Friday. Friday was a shit show in court. Banging your Aunt Angela. Well, I mean, this is it's the conversations we've been having for all this time. All of it. Well, not all of us, but some of us, and you know, one of the reasons why there was ridicule out there is because it's like, how could you dare? How could you dare say that he might be innocent? Because, right, Rolo? Months. That's right. All right, so this is where we were at earlier. There's about 11 minutes left in it, and I'll probably play a few more, pause it again, and then we'll finish it out here. And I want to say thank you, everybody, for hopping in. I appreciate it. I'm trying not to highlight the comments as much. That way it doesn't cover up the closed captioning. I wish they'd put it on top. That'd be cool.
It's going to be very difficult to put.
Yeah, it's going to get drug out like crazy now. Like, I don't know if I should save my PTO for the first week of the trial anymore, because I might have more PTO by the time the trial takes place. So what am I saving it for now?
This is a very significant, complicated case for all the lawyers, and particularly for Ms. Convo. So I understand we want to be fully prepared for the trial, and the captains also. So, and likewise for the state, likewise for the court. I mean, I just need to do that. But you don't want to have to. Any of these issues, because they're all important.
Right, Cole?
So I don't know, did you take a look at that form?
Maybe have just a moment.
Yeah, go ahead. Thank you. So, Mr. Koberger, did you read this over?
Yes.
Okay, what I'm talking about is the written waiver of speedy trial.
Yes.
Did you understand the terms here,
Yes.
which we've already talked about?
Yes.
And you agree with the signing the form waiver of speedy trial, Ms. Taylor?
I do not.
Okay, so Mr. Koberger, do you want me to accept your waiver?
Yes, I do.
Okay, and you understand that if I accept your waiver, you're giving up your constitutional right under the United States Constitution and the Idaho Constitution on a constitutional right of speedy trial?
I understand.
Do you understand that if I accept your waiver, you're also giving up your Idaho statutory right to a speedy trial?
Yes.
That is within 6 months of your arraignment.
Yes.
And you agree with the vendor of the waiver, Ms. Taylor? Koberger, do you want me to accept your waiver?
I do.
Based on our discussion, your waiver of these rights expressly in court and also signing this waiver of speedy trial. Also, you are tendering these waivers on advice of counsel. I will accept your waiver of speedy trial. I find that your waivers are knowing, intelligent, voluntary, and there's actually good cause to recognize that. Given what I heard from your counsel, Thompson, and my findings. So, with that, we can talk about resetting this problem. I'm prepared to do that today. Sarah?
Your Honor, I would say that we are not prepared to choose the trial date today. That brings me to the second part of what I wanted to talk to the court and counsel about today. We currently have September 1st as the date for the motions to dismiss the grand jury indictment. Our deadline to file our challenges will be today, and we're prepared to file those today. Our hope is that we can keep that particular hearing date. We'd like to keep it both to challenge the grand jury indictment, and also there are 2 additional motions that we're going to be filing, and we're hoping that we can have those heard. After that time, after we've heard the motions, we'd be in a position to meet with the state if we desire and talk about a reasonable trial setting. My preference would be to have us discuss that and reset the trial one time and not do this a number of times and worry about getting subpoenas out and that would be my request. The other deadlines that are in place right now on the court's scheduling order, I think those would be appropriate for us to talk about at the state and perhaps suggest for the court can order a different scheduling order than the one that exists. We just simply want to keep the grand jury indictment challenge date because that's soon, and having the court's decision on that will largely impact what that means. If the court will allow, I'd like to briefly address the other 2 motions that are coming from the top and bottom today.
Sure.
Okay. Your Honor, we will be filing a motion as to do with media in the courtroom, particularly to counts in the courtroom. And that motion should be filed by the end of today or first thing tomorrow. That comes from some things that happened last week. The other motion, Your Honor, has to do with what happens to witnesses that the defense might call. The court will recall that Gabriela Vargas testified last Friday in our hearing. Last night, she was visited by 2 FBI agents and interrogated about her testimony, the timing of her declaration. That, in our view, impacts Mr. Koberger's due process rights and his rights to effective assistance of counsel, and that motion will also be filed later today in first thing.
Any objection to hearing this here, the motion along with these 2 more motions to be heard on September 1, Mr. Thompson?
I don't believe so, Your Honor, having not seen exactly what the motions are, but you're saying they're fairly straightforward. I would think that you could, if we look at the motions, we have an issue with great support for Ms. Taylor. I will, for the record, since Ms. Taylor has brought up the situation with Vargas, getting court and counsel background. Over the weekend, Ms. Vargas, after she testified, engaged in some electronic communications with others in the genetic genealogy field. Those indicated, as it was reported to the investigators, to our investigators, that she was redigging on some of the things that she testified to in court. When we heard of that, I reached out to the investigators and said, can we find out what's going on? And the FBI indeed undertook an investigation. And preliminary reports are that Ms. Vargas claims that some of what was in her declaration, she inadvertently agreed to or signed without fully reading it. We're documenting that and exposed it to Ms. Taylor and to the court because I think those directly to what happened last week.
Hold on a minute. Somebody signed documentation without fully reading it, and that's an excuse? Wait, hold on a minute. Hold on a
Yeah,
minute.
can you rewind it?
Did you hear that too?
I did. I'm not sure that what I heard, but yeah, I heard something like that. Can you rewind it?
Yeah, I did too. I'm like, what? Somebody that huh?
Yeah, that doesn't.
Timing of the declaration.
What?
That, in our view, impacts Mr. Koberger's due process rights and his rights to
It is.
justice.
It is, everybody. I
And that
understand,
motion
but
can also be filed
it's
later today.
what they want to offer. They don't even want us.
Any objection to
I wish I could be in the
hearing
courtroom.
this,
That would give you guys a treat.
motion along with these two more motions to the
And I wouldn't be
third
wearing
on
my hat in the
September
courtroom, by the
1.
way.
Mr. Thompson?
I'd dress.
I don't believe so, Your Honor, having not seen exactly what the motions are, but understanding they're fairly straightforward. I would think that we could, with the motions, we have an issue with grace for Ms. Taylor. I will, for the record, since Ms. Taylor has brought up the situation with Vargas, did court and counsel background. Over the weekend, Ms. Vargas, after she testified, engaged in some electronic communications with others in the genetic genealogy field. Those indicated, as it was reported to the investigators, to our investigators, that she was redigging on some of the things that she testified to in court. When we heard of that, I reached out to the investigators and said, can we find out what's going on? And the FBI indeed undertook an investigation. And preliminary reports are that Ms. Vargas claims that some of what was in her declaration, she inadvertently agreed to or signed without fully reading it. We're documenting that so we can expose it to Ms. Taylor and to the court.
It's so hard to tell what the hell he's saying.
Expose it to the sailor?
You know what I'm saying? And listen, everybody, the transcript is the same as the closed captioning. It's not different. Like seriously, you can see the same. Expose it to the sailor. I'm having such a hard time. I almost want to turn closed captioning off because it's making me hear shit that I'm not hearing.
Yeah.
And
so I guess Vargas is saying that she signed it without reading it.
Well, they're saying that, and it's so hard to tell because of the closed it's YouTube closed captioning. They always butcher stuff. It sounds to me like some of the things that she was testifying to was based off of a report from a long time ago or something. I'm still kind of confused. But that the investigators reached out to her or something.
Maybe we need to hear it. Maybe we need to hear it one more time.
I gotta listen to it again. That part is clear. She signed it inadvertently without reading it.
Okay.
We get that part, everybody. What's the Vargas, the testimony, the electronic?
We have the prosecutor saying that she signed it without reading it. I don't know what that means.
Well, he's stating what she's stating, I think.
Yeah, but that's hearsay.
Because he said that he wanted the investigators to reach out because he was asking the investigators what's going on. So then that's when the investigators told him that she inadvertently signed something that she didn't fully read.
She inadvertently signed something?
Right, that she didn't fully read. Those are his words.
This is insane.
Inadvertently signed something that she didn't fully read.
Well, she was able to testify.
Thompson called the investigators to interrogate Vargas. Thank you, Heather. Yes.
Whoa. Okay. Well, I'll leave it up to you guys if you want to re-listen to it.
No, I do.
Okay.
I do. And then I'll get into that new document that dropped a little bit ago. We're going to listen to his part
The
again,
other
and
motion,
then we'll
Your
get to
Honor,
that document.
has to do with what happens to witnesses that the defense might call. The court will call Atty Yolie Dolphin.
This is why I want to be here for you guys every time this is out,
Last night, she was visited by 2 FBI agents and
or any of these
about
cases.
testimony, the timing of the declaration.
I wish I could be in the courtroom.
That,
I really
in
do.
our view, impacts Mr. Coberger's due process rights and his rights to effective assistance of counsel. And that motion will also be filed later today in the first reading.
Any objection to hearing this here, the motion along with these 2 more motions to be heard on September 1?
I don't believe so, Your Honor, having not seen exactly what the motions are, but understanding they're fairly straightforward. I would think that we could, with the motions, we have an issue with raising support for Ms. Taylor. I will, for the record, since Ms. Taylor has brought up the situation with Vargas, did court and counsel background. Over the weekend, Ms. Vargas, after she testified, engaged in some electronic communications with others in the genetic genealogy field.
So she testified about electronic communications in the genetic genealogy field.
Those indicated, as it was reported to the investigators, that she was relating on some of the things that she testified to.
She was relating to some of the things that she had to rereading. I can't. It's so. What is that?
Indicated, as it was reported to the investigators, that she was relating on some of the things that she testified to.
It says it was reported to some of the investigators. Who reported it to the investigators? Do we know?
Well, the investigators would have been the one that, so it would have to be another investigator that starts with an F.
Well, why wouldn't they say that she reported to the investigators? They said it was reported to the investigators. Who reported it?
Maybe he fumbles his words a lot because he talks out of his ass. And
No, I don't know.
You can fumble words easily that way when you're talking out of that hole instead of the other one. It happens.
Yeah, I guess so.
Shit comes out, you know. Yeah, it happens. Yeah, I'm having a hard time understanding what he's saying. Let me try and back it up. It's really hard. It's really hard to understand.
Those indicated, as it was reported to the investigators, that she was relating on some of the things that she testified.
Reneging.
When we heard of that,
is it reneging?
I think it was relating. Relating. Because it comes up rebating. So I'm thinking relating is what. But it could be, who knows? We'll listen.
As it was reported to the investigators, that she was relating on some of the things that she testified to in court. When we heard of that, I reached out to the investigators and said, can we find out what's going on? And the FBI indeed undertook an investigation. And preliminary reports are.
So he reached out to the investigators regarding what she was testifying to because it wasn't, quote, probably what he thought she was going to say. Is that what I'm hearing?
I don't know, but
I think that's what I'm hearing.
This is something for cross-examination. Why didn't He's basically making an excuse for why he didn't cross-examine her because this information was afterward. Because if he had this information when she testified, then he could have cross-examined her and said, "Well, didn't you say this?" You know. So
that
now
too, and you don't know how to ask questions either. I mean, I can come up with some good fucking questions, bro. Hire me. So I'll fill in.
I'm not sure. This is all very strange. I don't know what's going on here. It's very, very strange.
This shit is confusing, you know?
So
Wait a minute.
so
Oh,
so
I'm sorry. Go
somebody
ahead.
What do
so
you think, Dawn?
somebody said that she rebated or whatever it is on her testimony, that some of the things she said in her testimony either wasn't right or she was
Something didn't match.
reneging, or I don't
Yeah.
know. And
Something
so
didn't
it
match.
was reported to the investigators that she said that. So that's all I could really gather from that. But go ahead, Dolphin.
Oh,
Yeah, what do you
so what he said was that she was reneging on her
Reneging.
Oh, okay.
testimony. It's basically means that she said that she was going to testify to one thing, but when she got up on the stand, she started talking about something else. That's what Bill Thompson's problem is
Ah, well,
Right,
he had a
yeah.
with
chance,
her.
but he had a chance to cross-examine her. That's the thing.
I didn't
Um,
even see her testimony, so yeah.
I didn't either. That's why I was like,
I
where'd
saw a
it
little bit of
go?
it in Jules's video or whatever, but
Is it
yeah.
out is it out there now? Because I'd like to
Um,
watch it.
she put one up the weekend, last weekend.
mhm.
Like I said, when I had my aha moment, like a few hours later in the morning, she created a video along the same, lines of what I was thinking. So, and she
Well,
mentioned this Vargas woman, and there's a clip or two of Vargas in her video.
Mm.
I'll need to find out where that's at because that's we haven't gone into the witness's testimony part yet. That's after the DNA stuff. So I definitely need to hopefully it's available. Why wouldn't it be available? Because I I don't know, why wouldn't it be available? But it sounds to me like he was caught off guard. Is that why? I mean, he was already pissed off before she even was up on the stand then because he
She was a
was
last
upset.
minute witness too. That's why I think he was caught off guard.
Yeah, well, she submitted a declaration ahead of the hearing
Hmm.
at the last minute. And so you have a declaration, and maybe that's what she was comfortable giving, not an affidavit. Not, I mean, it's different, but she gave a declaration to show a preview to the judge about what she was going to testify to. But
Mm,
maybe she went outside of that, but I don't know.
mm. I don't know. All right, let me get. There's just a couple minutes left, and then there's a new document.
That Ms. Vargas claims that some of
It's
the
hard to hear them.
declaration she inadvertently agreed
Oh.
to her side without fully reading it.
Inadvertently agreed to sign, so somebody handed it to her.
Well, so the declaration is usually prepared by the attorney. The attorney gets the information from the witness and puts it in the format and
I even
gives.
know not to sign something without reading it, even if
Well,
it's
keep in mind this is a prosecutor who's saying that she inadvertently agreed to sign without fully reading. He is not he's saying that to the court, but where's the
so he
witness
wants her
saying that?
tossed. He wants her
Yeah,
tossed.
but he
He
can't
wants her
toss
tossed.
it. He can't toss it he himself. I mean, he
No.
has to show some proof that she
Yeah.
inadvertently agreed to sign without fully reading.
Well, right. He wants to show that she's not because I don't know. Maybe she didn't agree with because I'm gonna be honest with you. When I was watching some of these witnesses' testimonies, I was like, damn, they're kind of sounding like they're like on the side of who a little bit. I was like, whoa, that's pretty crazy. But if she really did this, he's not down with what she was testifying to, and now he's sending the hounds after her. I think is he just trying to play a game where he wants to not even be a credible witness because
I'm not sure.
stating two different things that are obviously don't jive
Well,
with
we haven't heard from the witness that she inadvertently agreed to sign without fully reading. We haven't heard that from her.
That's
We're
true.
hearing it from the prosecutor.
Yeah,
So
but he
the
can't say
prosecutor,
some shit like that. That's not true.
it's true he can't say that if it's not true, but he has to show the goods at some point.
Well, I mean, I don't think he'd be making the claim. You
Oh,
know,
well, I
you
don't
think
know.
he would say that right now without having the proof to show the judge? I would think he would have the proof.
Well,
I don't think he'd be saying it if he
he's
did.
filing charges against Brian Kober without showing the goods. I mean, I don't
Yeah,
know.
I understand that, but that's been a work in progress for 8 months, 7 months. This right here, this just came out of the blue.
Well,
So
what he needs to
that's why
do
I'm
is,
saying I could see how it is true if if he.
well, here's the thing: whether she signed the declaration inadvertently and agreed and signed, she still gave her
That's not good.
testimony.
That's not good.
Well, she still gave her
Right.
testimony. So,
I think he's trying to expose shit so she's not even a witness in trial.
but what the prosecutor says is not evidence. It's just not.
No, I'm not saying it's evidence. Okay, what I'm saying is, Yoli, is that when you're building a case for 7 months, yes, you can put a DP on somebody. When something comes out of the blue, like what the testimony was yesterday or was
Yesterday,
Friday.
wasn't it? Oh, Friday.
No, it was Friday. So, and then they had the weekend, and then they had to wait. But what I'm saying is that was out of the blue. So because it's out of the blue, because he didn't have time to really prepare this elaborate freaking thing like he would for 7 months, that's why I'm saying I see some kind of merit to it, because I don't think he'd be saying that shit right now with it being that fresh of an event, and then not being able to provide the documentation, because to sit there and say that a witness that testified was doing this, that's some heavy shit. And that's like right off, that was just Friday. It wasn't 7 months ago.
Right. But the judge can't really act on this.
I didn't say he could.
Right. So
I said what I'm saying is I think his words have merit. I didn't say the judge could do anything.
I don't know.
I think what Bill Thompson is saying is actually, I think he does have the documentation to back it up, is what I mean.
What I'm saying is I don't know if he does or not. Because they don't have the documentation for the DNA.
Well,
and they don't have documentation.
I don't know. The water cooler, but I'll just say, in my opinion, I feel like he does have the documentation to show that, because I don't think he would.
And what documentation would that be?
You don't think the judge would be asking him ASAP where the documentation is at?
Well,
when it comes to a material witness? Not today, but there's a lot of court hearings coming up.
Yeah. Well, maybe it'll come out in the court hearings, but right now, I don't know if what he's saying is true or not true, or if he is just saying that somebody informed somebody that she inadvertently signed without fully reading, and then later on he's going to say, well, I don't know, I was informed by somebody, I don't know.
I mean, yeah, he could easily do that. I'm not at the water cooler. I always state that about these cases that I cover. I ain't at the water cooler. This is just my opinion. And in my opinion, I feel like he probably has them.
Well, we'll see.
My opinion. It's just my opinion. I'm not placing a bet on it.
Well, we'll see. Yeah. I mean, I don't even know what to make of this. This is all crazy. I don't know. And you know what? I don't
Why didn't he just make up an elaborate lie about the documentation if he was going to make up an elaborate lie about a testimony from a witness?
Well, it could.
He didn't lie about it on Friday, so why would he lie about? That's
well, it could be that Vargas is not. I mean, she's not as like I would say a seasoned. Well, I don't know if she's a seasoned expert or not.
See, she's the witness that spoke out about Ellie breaking the rules.
Yeah.
Well,
I don't know. Yeah. I mean, let's.
I mean, who really knows? Who does? Unless you're at the water cooler. That's why I always bring up the water cooler, because when you're at the water cooler, that's where all the conversations are going down. You know that if you have a water cooler and you walk by it, that water cooler, that's where all the conversations take place. You know that.
Yeah.
We are that Ms. Vargas claims that some of what was in her declaration, she inadvertently agreed to or signed without fully reading it. we're documenting that so we can expose it to the state and to the court, because I think those directly to what happened last week. That's the only reason that she was contacted, because it was important to us that she was retracting some of what she had testified to, what was in the declaration, and we felt it very need to cover that system. There was no other motive, no other motivation for it. I just wanted to candid.
Oh, wait a second. Can you pause for a
Yeah,
second?
you want me to pause it? Yeah, go ahead.
Yeah, just for a second. Because I
Yeah.
got up to turn on my outdoor lights. So when I came back, you guys were talking about Vargas and the declaration and all that. I pulled up the declaration, but I missed what they said in court. So was he just talking about that because she signed this, that's why, and then she reneged on her testimony. That's why the FBI contacted Vargas. Is that what he was just talking about? Is it the FBI contacted her?
Thompson wanted them to go find out what was going on.
Oh, so he sent them. Okay.
He requested it.
Okay. Well, at the very bottom of this declaration, she just says one simple sentence that she's aware that law enforcement has obtained results in ways prohibited by the terms of use and prohibited by their own policies. So it's, just one simple statement. But I think when she was on the stand, she pulls out like an article and something else and then says, yeah, they've been using it. The article, I think, says that Ellie has been doing this and they have been hiding it for like a long time. And she, kind of like went in depth on the stand.
Listen, I've heard of the same county almost not like doing this little MO shit where they put these crazy ass amounts on these fucking people there. So they will fucking take plea deals so they don't have to provide the fucking evidence. I'm telling you. I'm telling you. Look it up.
I wouldn't be surprised.
This shit ain't no joke. They do this shit. And then they get these fucking people to take plea deals because the fucking charges are so fucking ridiculous. And shit gets manipulated. And then they fucking take plea deals so they don't have to provide the fucking evidence. Look it up. Trust me, I it's not that hard. It doesn't with shit up there, it don't take that long. It really don't.
Well, here's the thing. You have the prosecutor saying this, but is it like he's telling the court this, and I mean, we don't know what's going to happen, right? I mean, he's saying this. So what does he want? He wants what? He hasn't said what he wants or why he's arguing this.
He's probably arguing it to get her testimony stricken from the record.
That's what I'm
thinking.
He
said that
I'm
yet?
thinking he doesn't want her. I think he doesn't want her.
No, I think there's more coming. I don't know.
I think he doesn't want. After that, it's like, you know what? You're gonna flip the script. Get the fuck out of here. No, for real. That's what that's what I've been picking up from it, is like, why else? Why wouldn't you like sit down and have a conversation with the witness yourself? Why are you sending investigators? You know what I mean? That's what I'm looking at. Like,
well,
why are you sending? And that's why I think that if it's true, he does have the freaking paperwork. Because
the reason why he
really
sends
did.
The reason why he sends investigators is because he doesn't want to be a witness to the case. So that's one of the things that attorneys use. They send investigators because if they ask the question, let's say I interview a witness and they tell me something, and then they get on the stand and they say something else. Well, I don't have a witness to rebut that witness. I'm the only witness. And if I become a witness in the case, I can't. It's a conflict. So you send an investigator to get the information so that the witness reneges. Then you have the investigator get up on there and say, she told me this.
Right.
So that's why he has it. But I don't know what.
It had to be an investigator. It couldn't have been somebody like some kind of representation.
Oh, it could be anybody.
Why would it have to be an investigator? So it doesn't have to be. What I mean is,
not at all.
I think there's a reason that you called an investigator and you didn't have a simple conversation.
Oh, I see what you're saying. Okay,
you know what I mean?
Yeah, I see what you're saying.
Yeah.
I don't know. I mean, it's an investigator, I guess, because they have access to. They're privy to getting investigators to go out and investigate, and I guess, I mean,
Yeah, it's like going to the principal without taking the student out to have a talk with them,
right,
outside the room.
right. Yes.
You're just going straight to the principal. It's like, whoa, why? Why are you doing that?
Yeah, criminal law is very different because in civil we take depositions and and they do that in criminal, but I don't know about this whole deal. It just sounds very strange to me.
It does. It makes it all. It does. It's so confusing, but then it just. I almost feel like it's sad too because with these court hearings, it's nice being able to see it. It's nice being able to hear it because it can take on a different story if you're just reading the words because you add your own emotion into the words and you're not getting the true emotion physically or verbally from the real people that are speaking the words. And it almost seems like these layers are getting peeled back with each one of these court hearings, and it's sad that this shit's going to be taken away, because it really feels like shit. Each time there's some kind of hearing that we're watching a new video, there's always a little layer that just gets peeled off each time, and it just keeps exposing shit. That's just my opinion, though.
Yeah,
It just seems that way.
and that's probably how it's going to go.
I mean, and I'm saying against the prosecution.
Yes.
It's Friday. It was, the obviously Vargas's testimony. It was appeal. Another appeal, was, finally admitting how can we supply something that doesn't exist?
Well, yeah. I mean, the
admitting
reason
that
why
the other DNA samples weren't tested because they weren't
qualified.
Yeah, qualified.
I don't know what that
like
means.
peel, like peel.
God, I wish
And
I
now
could just
this,
go in there and cross-examine everybody. They
right?
like
Oh,
there would be. It's just like waste of time. It's like get to the point, Like
yeah.
I don't know. I'm not a criminal defense attorney, but if I were representing Brian Koberger, I would say the simple question is how did he become a suspect? That's what I want the defense to tell me, and that's what I want the defense to tell the court. How did he become a suspect? Tell me.
Mm-hmm. Yeah.
And what would they say?
And they'll say, we don't have the documentation.
Well, then you know what? Fuck you. Go. It's dismissed. I'm sorry. I get so
That's why
angry.
I don't think they did the work. No, that's why I don't think they did the work.
Angry. See, I need to
I don't
calm
think
down.
they did the work. I don't think they did the work. I just don't see it.
I shouldn't be saying things like that. I'm sorry.
Why? Hey, it's the Evil CJ show. You can say all the swear words you want to. It don't matter. That's the beautiful thing. We express our emotions. It's an emotion. Express it, if you want to say fuck or shit because you're angry, well, then say fuck or shit because you're angry because, sometimes we need to say some shit. We need to get upset. We need to, we need to do it,
I'm just because I'm an attorney that I feel like, some people might listen to this and they might say, oh, look at this chick saying this shit. But you know what?
Have you seen Emily D. Baker?
Right. It could be worse. You're beautiful the way you are.
She said she's a fan of the cursey words.
You just keep being you.
Well,
I get excited when you swear. I'm just being serious.
I just wish I could get in there. Like, okay, let's stop it. Okay. Okay, why is my client in jail? Why is he locked up? Just tell me. Tell me the basis for which you determined he was a suspect. If you're going to hem and haw, well, guess what? That's not going to work. I feel like I would not have gotten out of that. I would have kicked and screamed. I would not have gotten out of that courtroom until I had some definitive evidence that backs up why he's in there. And I don't see it. And maybe it's because it's under a gag order, that we don't see it. That could be it, that there's evidence, but it's all quiet and we can't see it. And so therefore.
I'm sorry. You're gonna have these, if anything. You're gonna have these, if anything. Like,
Eddie,
seriously.
he said swear like Trailer Park Tammy
Well,
with the cigarette.
yeah, I feel like that. I feel like, you know what?
Oh God.
Trailer Trash Chat.
We don't
I
talk
saw her.
politics in here, Special
Oh my,
K.
no, no,
Sorry.
no. I saw her videos at Trailer. Yes, Tammy. Wait, is that? Yeah. No, it just bugs me. It's like I want to just go in there and say, look, judge, how did my client become a suspect? That's the first question. If they can't answer that, then he shouldn't be in jail. But that's just me. I don't know if that's how it works in criminal law.
You're just you, and we are just we, and that's all we can
I'd be kicking and screaming. And you know what? I've been under the media coverage, and I know you have to be sort of subdued, but with this case, the way that I feel, it's like, oh my God, like seriously, like, do you think we're stupid?
Right. Yeah, it's ridiculous. Seriously. And trust me, I don't know. I would love to be able to. That's why, like, maybe in the future, I'm just going to have my own damn website. And then I can be able to say whatever the fuck I want to say, and I don't have to be, I can talk about different countries and I can talk about other topics, and I can say certain things that, so trust me, I'm like, it sucks being with all of the restrictions we have as content creators on what we can say and what we can't say and what we can talk about and what we can't talk about. It's ridiculous. It almost is like some small censorship in a way. And the crazy part is when you choose to be an 18 plus channel, like, you already are starting off like way at the fucking bottom. Because yes, I'm going to swear. Yes, I'm going to talk about topics that isn't for everybody, different things like that. And and then you already have that. So then your like reach is like very freaking limited. Okay. So you're already like very fucking limited. Some people choose not to and just go the other route, which I don't know. I like to be honest, about the audience that I'm trying to have. And shit. I'm sorry. But then with the restrictions of like all the words and things that you can't talk about, you can't even talk about some current events that go on, because if you say anything about it, you're getting in trouble. And it's like, well, why can't we talk about these things? And the whole like restrictions is it's just it's getting ridiculous. And I'd love to be able to be on a platform where I could say whatever, we can talk about whatever. um in the very future, there will be something like that, because I don't know, I just see things getting worse and worse here when it comes to the restrictions. And I don't know, pretty soon, I deal with them. I deal with them on the analytics in the studio. I'm dealing with these things on every show. And it's like, you if I even showed you guys like like the things that you got to check off to submit for a rating, it's crazy. It is crazy. It's absolutely crazy. And the fact that like, if you don't even do it right, you can get in trouble for that, for just not even clicking on one of them as something that took place, might have taken place or took place in the video or the content. It's a I don't know. It's getting harder and harder and harder and harder.
Well,
And
I don't
pretty
want to
soon,
cause any
you ain't going to
problems,
be able
so
to question stuff.
I don't want to say the F word again.
Oh, you're fine. No, that word, no, that's why I say I don't care about the quilted northern money. Because, no, I really don't. Because I would rather you be able to feel free to say the F word than YouTube being happy with the F word not being spoken. So tissue paper can have a freaking ad rolling on this video instead of ShamWow.
Yeah.
I'll deal with ShamWow so you can be comfortable saying the words you want to say. Now, there's other words. Those are the words that we all know we can't say, because that's when we can really get in trouble as content creators. But when it comes to the swearing and stuff like that,
Yeah, like
no,
for me to be out
no,
here
that's
swearing
just
on
different
YouTube,
advertising.
nobody would ever expect me to be out here on YouTube swearing. But this case has gotten under my skin just like it has a lot of other people. So, I don't know. There's something about this case, and I really can't articulate it like what it is. It's just a feeling, and it gets under my skin.
It all has, since Fry was out there in the gravel parking lot saying unalive, self-unalive, and the community has nothing to worry about ever since. Like, this show wasn't good. The Evil CJ show wasn't going to be mostly true crime. It wasn't. And this is the case that made me go, this shit ain't right, y'all. From the fucking beginning, I'm like, this shit ain't right. And this is why the show has turned into what it is mostly, is because of this case right here.
Yeah.
And then it started getting me interested in these other ones, digging into stuff and this and that. And it's this case right here. It's from the very beginning. It's been, what the fuck?
Yeah.
The fuck?
And I just had a thought, and it's just a thought, but why, like when they went all gung-ho at BK's parents' house where he was at, I'm wondering, did they think that he was gonna do something crazy so that they could engage in some kind of like war thing with him, and like they did with Brent Kopaka? I don't know. I just thought about that, but my mind's just going. But the whole
There's so many things, It's like, man,
yeah, and I don't want to go there, but it was a thought that crossed my mind, because I don't understand why they had the whole fucking SWAT team breaking doors, breaking windows. It's like, do you want somebody to come out with a shotgun because they're scared?
well, I mean, I have my own opinion on that shit.
Yeah, we don't have to go there. It's just a thought I had.
Yeah.
I don't even want to think about it.
I mean, it is mesmerizing. And I think it is mesmerizing, but I think it's a great learning tool. And I think it's a learning tool for the younger generations, to the negative and the positive, because there's so many questions on both sides with this case. And
Yeah.
to see, to see it all unfold, and it's unfortunate for the victims, obviously, and the families, but to see it take place and like even these court hearings, somebody that's a young child is going to be watching these, or something, teenager is going to be watching these, and they're going to be seeing this stuff, and they're going to be saying the same shit on either side. Oh wow, this makes sense, or oh wow, this doesn't make sense, and they're going to start to explore it. Like, I just don't understand. This is one of those cases. Like, are you going to tell me none of us learned shit from the O.J. Simpson case? None of us learned shit from
Yeah.
O.J. Simpson case. Really? And how impactful that case was. To me, this is going to be bigger than that.
I think
It
so.
is. It is. And so it's like,
that's all the more reason why they should televise it. But I can't imagine what pressure the judge is under. I mean, I can't imagine what pressure the prosecution, defense counsel, judge, they're all under so much pressure that if I kind of understand it. I've been under that not exactly that kind of pressure, but under pressure where the media is watching, and it's a different story. I mean, you have to think differently. It's you can't even imagine. But the thing is it is going to be a learning experience. And I think about it, and I think yeah, they had this whole so with the list killer, they just quietly arrested him on the streets, people with suits. They went ahead
and I saw the PCA, and I couldn't even do a
it was
highlight
too long.
video. No, not that it was Yoli, not that it
But it
was
was
too long.
awful. The
I
details.
started to read through it. I did a proofread thing before I went to do a highlight video because I was going to make it that Saturday morning. And I got through like 10 or 11 pages, and I'm just like, there's no way I can make a freaking highlight video out of this and feel comfortable putting it out there like that. I'll read it on a live where I
And
can
yet they went ahead
self-edit,
with
but I am not putting that document. No, it was
they went ahead.
horrible.
So with that PCA, they went ahead and arrested the list killer out in the street with people with suits, very peaceful, very quiet. Here you go.
Right.
You're
Yeah.
under arrest.
Yeah, right by the
Okay,
trash
but with
can.
with BK, they went ahead gung ho. Like, what did they expect? And stupid. Excuse me. I don't want to say that. But these FBI agents, they went gung ho in there, and what did they find? They found Brian Kohlberger in his, what I understand, boxers separating trash. So I don't know. I don't know what they thought they were going to get, but they had to say, oh, he was separating trash because he was so worried about his DNA and he wanted to make sure nobody got his DNA. Yeah. Well, I don't know that that's true, but they didn't. They basically found somebody who was separating the trash. And I know we have to get back to this hearing, so I'll be quiet.
Right. Yep. Hold on one second. Yeah, this is going to be, I'm going to back up to what Bill Thompson was saying, and then you can hear Ann Taylor's response.
In our view,
And then we have that new document too. Yeah, without body cams, right?
Oh my God.
Dang it.
Any objection to
Come on,
hearing
StreamYard.
the motion along with these two more motions to be heard on September 1, Mr. Thompson?
I don't believe so, Your Honor, having not seen exactly what the motions are, but if you're saying they're fairly straightforward, I would think that we could look at the motions, we have an issue with great support for Ms. Taylor. I will, for the record, since Ms. Taylor has brought up the situation with Vargas, did court and counsel background. Over the weekend, Ms. Vargas, after she testified, engaged in some electronic communications with others in the genetic genealogy field. Those indicated, as it was reported to the investigators, to our investigators, that she was redigging on some of the things that she testified to in court. When we heard of that, I reached out to the investigators and said, can you find out what's going on? And the FBI indeed undertook an investigation. And preliminary reports are that Ms. Vargas claims that some of what was in her declaration, she inadvertently agreed or signed without fully reading it. We're documenting that so we can expose it to Ms. Taylor and to the court, because I think goes directly to what happened last week. That's the only reason that she was contacted, because it reported to us that she was retracting some of what she had testified to and what was in her declaration. And we felt in fairness we needed to uncover that quickly. There was no other motive, no other motivation to it. I just wanted to cancel the court.
Your Honor, that's certainly different than the information that I received.
What happened? The camera froze?
That's how we sort these things out.
Yes.
Hold on. I think the camera froze. Let me just rewind it. Yeah, the camera must have froze. Okay.
Yeah.
That's how we sort these things out.
Yes.
So,
Are you serious? Look at that. Oh, of course. Of course.
Your Honor, that's certainly different than the information that I received. I would have been happy to be advised about that, but I'm not sure that's accurate. I mean, I'm sure that's what Mr. Thompson heard. I'm not saying they're calling him a liar, but the quality of the information he's received, I'm not sure that's entirely accurate. My hope is that these two FBI agents that were at Ms. Vargas' home last night, hopefully they reported everything that they talked to her about, and that should resolve the issue with us.
Okay, great. You're not at the hearing. That's how we sort these things out. Yeah. So.
Okay, I couldn't even see the closed captioning. It didn't even.
No.
Did you hear what she said? I couldn't understand what she was saying.
I didn't understand anything. Something about,
I didn't see the.
well, we don't know. I don't know. I didn't hear.
Okay, hold on. Okay. You're at the.
Yeah. So,
this is so hard. I don't know why it needs to be this difficult. You know,
the information that I received,
it should be clear.
I would have been happy to be advised about that, but I'm not sure that's accurate. I mean, I'm sure that's what Mr. Thompson heard. I'm not standing here calling him a liar, but the quality of the information he's received, I'm not sure that's entirely accurate.
Oh, okay. So she's saying that she feels the information he received is not entirely accurate. So maybe subtitle, he's misrepresenting the information. So he could easily blame it on, well, that's like what you were saying earlier. Well, he could just say, well, somebody told me. So he's embellishing in something because he can basically pawn it off to somebody else if he gets asked, give me the shit. And I think that's what she's saying. I don't know. Let me know in chat if you think that's what she's saying. I think. Here, let me just play it out. One more minute, and then we'll be done here.
Accurate. My hope is that these two FBI agents that were at Ms. Vargas' home last night, hopefully they reported everything that they talked to her about.
So she's saying she hopes they kept reports. She hopes they kept reports and they have that available if it is true. Okay.
You're not at the hearing. That's how we sort these things out. Yeah. So back to a change of the scheduling order. I mean, I think it does make some sense to do that. You want to just talk about that before we start taking that apart? We don't have to do it right now. So.
Judge, the state's position would be is that the court vacate the October trial date, vacate the scheduling order. Let's get through what we're going to do on the 1st, and then let's talk.
And then what? What the? It just cut off. So he's basically saying, I want the, they're requesting to vacate all of the dates of the paper, the document that was released yesterday. Basically, all those dates are going to be, it was a waste of paper. It's a waste of paper.